Dr. Hogg, you in your written submission suggest that some more appropriate regulatory framework could be designed to hold those to account who negligently expose people to asbestos. Could you give us some idea of how you envisage that such a scheme would work and what compensation that victims could expect?
Well, I'm not even sure it would necessarily involve compensation. There's probably two ways you could approach this. One is you could really try to firm up the rules you have in place about exposing people to noxious substances. And you could develop that. It's not an issue I've thought about in particular depth, but I'm really suggesting it as one alternative. You try and prevent the exposure from happening in the first place. That, of course, would also have costs to industry, to occupiers of buildings. The other thing you might do is to look at the scheme which the Westminster Parliament is proposing for England and Wales, the no-fault compensation scheme. That would certainly take the pressure off individual employers and insurers and replace it with a statutory compensation scheme. That wouldn't really address my fundamental concern that you'd still be compensating people from public funds for something which wasn't traditionally considered to be an injury, but it would at least perhaps be moving the burden of paying for that away from the private sector to the public sector. You might not want to do that because you might feel that would be letting people off for their negligence. But I think the point I was suggesting in my concluding paragraphs of my submissions were that there are other things to think about. And I think the Ministry of Justice's paper, with respect, throws the debate a bit wider than this bill does, because it's at least considering that there are alternatives to allowing a right in damages and delict for compensating people for plural plaques. And I think perhaps the Scottish Parliament seems to have closed off the alternatives too early without considering what they might be. But I haven't looked at what they might be in great detail. I'm merely suggesting that there are other routes you might consider.
I take back to the point where you raised issues concerning there's other elements of litigation that could come forward in other areas of other industries. Do you accept though that asbestos and exposure to asbestos is a specific area where the government, I think the Justice Minister's made this point, where there is a need to take that issue forward and to recognise the wrongs of the past?
Yes, I suspect, because I'm prepared to be corrected by a medical colleague on this, that this is the biggest incidence of exposure of a noxious substance which can lead to symptomatic conditions. But I don't think it's just a numbers game. I think if there are other categories of condition which may begin as asymptomatic conditions and possibly could go on to become symptomatic conditions, it seems rather unfair to people who might be in those categories of case not to consider their symptoms too. Because, for example, that's what in Florida they've done. They've said, we're not simply going to legislate about asbestos, we're also going to legislate about silica, and they have looked at that in a more broader context.
But do you accept that's an issue for Parliament? I mean, whilst I appreciate your
of course it is,
issue for commenting the academic contribution, but it's an issue for parliamentarians to look at this particular issue, and they shouldn't be affected. In terms of how to take this legislation forward, shouldn't be affected by the fact that somebody else might want to come forward with another case. I mean, why should that affect us?
Of course, but I was suggesting that sensible law reform would look at the issue of exposure to noxious substances which creates risk in the round, because if you simply do things a little bit at a time, you don't have a coherent, in my opinion, way of reforming the law. And just looking at asbestos, I think, masks the underlying problem, that what you're doing is tinkering with the rule about when you have actionable damage. So I think actually doing it one bit at a time sort of plasters over the underlying problem that's being created by just doing it one thing at a time, which is that you are tinkering with well-established rules of when someone has suffered a personal injury. And to just pick one condition out for no apparent reason that I can see, apart from that it produces the greatest number of cases, doesn't give a good impression, I think, on the sort of international stage, I would suggest.
Could you just ask why are they well-established rules?
Because over hundreds of years, people have brought litigation before the courts saying, I've been injured, and the courts have, over a great period of time, developed the idea of when somebody should be considered to be injured. And so you've had this great sort of, the sands of time have helped to create the marks of harm which the legal system recognises. And to change one of those marks of harm, which have been long established, without, I think, seeming to know why you're doing it, is a slightly dangerous thing. The common law of direct, the common law of obligations in general, works very well because it is a great sifting of the rules over a long period of time, at the end of which I think good sense and justice seem to be done, and suddenly we're changing tack, and I'm not quite sure why.